May it please the court. I'm Sylvia Walbolt from Carlton Fields. With me at council table is Matt Canigliera. He's going to assist me if I am unable to hear. I'm very severely hearing impaired, so I may turn to him to help me if I don't understand. We'd like to reserve 5 minutes.
Yes.
And I'd like to start by answering the question that the court posed in its order setting this hearing, which is to say, yes, this court has jurisdiction even if the trial court was not asserted to have violated a Florida Supreme Court decision. And there are a number of decisions that we believe establish that proposition pretty clearly. The Rodriguez case in 2013 of the Florida Supreme Court held that the threshold jurisdictional requirement for a writ of cert is irreparable harm. And this court has similarly held that that's the jurisdictional requirement in a number of decisions. The DeSantis decision in 2020, People's Trust in 2022, and most recently in statewide guardian ad litem this year. Then, in order to grant the petition on the merits, then the court turns to the issue of whether the trial judge departed from the essential requirements of the law. But that's not a jurisdictional requirement, that's the merits of the petition. And to the extent this court, in framing the question, was asking whether a district court decision can be clearly established law if it's not Florida Supreme Court precedent, but rather is a DCA decision. Again, the answer is yes. Under Caclamanis, and we can file the cites with the court after this hearing if that would be helpful. The Florida Supreme Court said that clearly established law includes controlling case law involving the same issue of law, and under Pardo, the Florida Supreme Court again held that decisions represent the law of Florida, decisions of the District Court of Appeal constitute the law of Florida unless and until they are overruled.
Don't those decisions, I mean, to the extent that there is a decision that comes out of the Supreme Court or a DCA, it's not the opinion itself that's the law, it's the law that's being interpreted that's the law. Is that not correct?
Decision is reflected by the terms of the opinion, and the opinion is going to explain what is the law that's controlling the decision.
Right. I mean, well, I'm sorry, when I said decision, I mean the opinion. But the opinion is just evidence or a reflection of what the law is. It's the legislature that makes the law in the state of Florida. It's the Constitution that is the law of the state of Florida. Not what we say, not what the Supreme Court says. So when we talk about decisions or opinions being part of the law, or even in the Supreme Court decisions talking about it, isn't what the Supreme Court really saying is that to the extent that the Supreme Court or one of the DCAs interprets or applies either a statute or the Constitution, that has the force of law with respect to the law itself.
With respect to the issue that's being presented
Sure.
by the case.
Right.
Yeah, and so we believe that answers the question, yes, that when the issue is one of law for the court to decide, the decision of a district court is going to be the established law on that issue unless and until it's overruled by the Florida Supreme Court.
Sure. But in the context of discovery, what is the law being applied?
When is the law? law is being applied by the trial judge on the motion that is before it.
Sure, but what is the law itself? I mean, if the law is the Constitution and the statutes in the state of Florida.
Well, the discovery comes from a variety of sources. It comes from the rules. To some extent, it may come from statutes. But the issue that is presented in this case is one that has been developed by the courts over many, many years. And that is the test for when a plaintiff in a products case is entitled to obtain discovery with respect to products that are different, that are not the same as a product that allegedly injured him. And that is a test that has been developed by the courts over many, many years to implement the requirements of the discovery rules, that discovery is only to be allowed if it relates to the injury caused. And so that's the kind of the predicate. Most of these cases that deal with the requirement of substantial similarity look back to that initial predicate of that discovery is, in a products case, is only going to be allowed if it is connected to the actual injury from the product used by the plaintiff. I hope I've answered the question. I find sometimes I answer questions that weren't asked, so just try it again. But I think just following up on your question, the case law issue here for us, and I'm sure you're going to hear this from my opponent, is the extent to which, when it's a question of a discovery order, what is a jurisdiction over discovery, certiorari jurisdiction over discovery orders. And the Florida Supreme Court came out with a case a couple years ago called Internal Improvement, in which it held that the mere allegation or even showing of overbreadth of discovery was not in itself sufficient to show irreparable harm, and thus insufficient to show jurisdiction. But in holding that, it didn't say there never can be jurisdiction, certiorari jurisdiction to address a discovery order. It specifically adhered to its earlier decision in a case called Langston, in which they said all we're saying is that overbreadth alone is not sufficient to automatically create irreparable harm.
Right.
But then
and
the court
go ahead.
went on to say, and if I could just finish it because this is important, the court went on to say that having said that a litigant is not entitled to carte blanche discovery, and that certiorari is appropriate where discovery is allowed, quote, even when it has been affirmatively established that such discovery was not legally relevant. And we think this case squarely fits within that test, because the issue here is one that's very common to products cases. And over the years, the courts have, as I said earlier, the courts have developed a legal test for when they're going to allow discovery, not just with respect to the product that the plaintiff actually used and says was defective, but earlier products, earlier models, and the like. And they've imposed the burden on the plaintiff to come forward with evidence that the other products or the earlier models of the same product that they are seeking discovery on, that in order to get that discovery, they have to show that those earlier models or other products are substantially similar with respect to the matters that are alleged to be negligent, to be defective. And here the plaintiff made no attempt to show that. The plaintiff presented an argument that basically said nothing more than The can looks the same from the outside, and it's got the same name on it, so it's the same product. The defendant came forward then with considerable scientific evidence that several years before the product that this plaintiff used was manufactured, several years earlier, the design and the specifications had been dramatically modified, specifically with respect to the components within the can and the valve, which is what was alleged to be negligently designed and defective.
What is the actual harm, though, to your client for having to produce? And I should ask first: has your client produced documents in response to the discovery request? I know that it was mentioned in the petition that there was a response to discovery, but were documents actually produced in this case?
Your Honor, that we think the actual harm to our client is considerable, and it's both substantive and it's procedural. And the first harm to us is if this test cannot be enforced against a trial judge who hasn't applied it properly, it's never going to be enforced. The production of the materials will have been made. There's no way to get them back. They're now a matter of public domain.
But they're not trade secrets, right? I mean, there's not been a claim of trade secret in this case. Is that correct?
We would contend, Your Honor, that they involved not only trade secrets, but sensitive business information. It's certainly information that is not publicly usually available, not information we would like our competitors to have. And I would urge this court to read the discovery requests that we're talking about, and I think you'll understand the harm. They're extremely broad, going back for more than a decade, and it shows the evolution of this particular product and how it was changed so dramatically in 2019 with respect to the precise parts of the product that are alleged to be
But isn't that reasonably calculated to lead to relevant evidence if the prior products?
Your Honor, the courts, the answer I would say is no. The courts have over the years said it's not reasonably likely. Remember, it's got to be likely, not just is there some chance out there. It's not reasonably likely to lead to relevant evidence. They made that determination as a matter of law where there's no similarity between them. If you've changed...
But this was the same, this was Flex Clear. This was limited to Flex Seal Clear. Isn't it possible or likely or reasonably calculated that, again, I'm not suggesting this happened, but the allegation that your client changed the product to the detriment of safety?
Well, the evidence is clear. We changed the product, and we changed the product with respect to the precise aspects of the product that are alleged to have been negligent.
But I mean, I don't know what the plaintiff's theory is going to be at trial to a great extent, but I assume the argument is going to be, in some sense, that your client either negligently or purposely changed the product for a cheaper manufacturing process that endangered public safety.
The reason that we changed the product, Judge, should never come in. The question is irrelevant, and I would say if anything, the change favors
But what if the prior
manufacturer who has
what if the prior manifestations of the product were more safe and your client made it less safe in order to reduce costs or whatever? Isn't that relevant?
There's not
or reasonably calculated to be
not
relevant?
a shred of evidence.
I understand you're not conceding that. I'm asking you, could that be relevant?
But we presented evidence that it was changed to address these components that are alleged to be negligently designed. The plaintiff presented no evidence at all. The plaintiff didn't make any of these arguments. The plaintiff's argument was the can looks the same from the outside and it's got the same name on it. That's the end of the inquiry. And I submit to you that is not the end of the inquiry under settled case law that has been developed over many years to address this precise issue. And how fast it goes. And just to conclude, again, I want to emphasize that these are questions maybe you get to with respect to the merits, but they don't go to the jurisdictional issue of whether there's irreparable harm, which there is, not only because we can't undo this production, but because it's going to impact the rest of the proceeding, because now the manufacturer is going to have to be defending prior products and why, and explaining prior claims. Thank you, Your Honor.
Thank you.
One more question, add it to the.
Just wait to rebuttal. Sorry.
May it please the court, Rebecca Creed on behalf of the plaintiff. With me is Nick McNamara. With regard to the question that was posed, we would agree that the two prongs going to irreparable harm are technically the jurisdictional requirements. But as to the failure to show that this trial court's order departs from clearly established law, that is a requirement of certiorari relief, and certainly this court can and should decline to grant certiorari where there has been no showing of a departure from the clearly established requirements.
Yes, I mean, it appears, at least to me, on the surface at least, this is why we're having an argument, that if a court has certiorari jurisdiction every time a discovery order is challenged based on relevance, which seems to me to be the argument here, then that's just unlimited. And every single discovery order, whether it be over breadth or relevance, is going to trigger our jurisdiction, and obviously the focus order addresses that.
Yes, and that's clearly not the intent under the Florida Rules of Appellate Procedure, which narrowly define the categories of non-final orders that can be appealed, and also the Florida Supreme Court's jurisdiction, particularly as most recently stated in a case we cite, State versus Garcia, which addresses
I'm
the
aware of
limited
Garcia
nature.
where they said even a criminal defendant cannot obtain certiorari jurisdiction to protest turning over a phone passcode, which could result in a conviction in his imprisonment.
Correct.
His remedy is on direct appeal.
Yes.
We actually said something very similar in a case we wrote. But yeah, if a criminal defendant cannot trigger an appellate court certiorari jurisdiction, where if you play out the possibility in Garcia and in the case we had, that defendant must turn over the passcode. The passcode can be used to produce evidence, obtain evidence used against that defendant. That defendant can be convicted and sentenced to life imprisonment. He may or may not qualify for a supersedious bond. He will then be imprisoned pending appeal, which can take years.
Yes.
Occasionally, and thus that's not irreparable harm. So how is it irreparable harm when there's no specific allegation of trade secret or some other substantive privilege in any discovery order, not just yours?
So then I think, our case does not even address the confidentiality and the trade secret and attorney-client privilege issues because those were never brought to the trial court's attention.
So it seems the argument of the petitioner is it's somehow fundamentally unfair for us to have to defend a prior manifestation of the product. Is that, am I missing
That's
something?
correct, and I would like to make a couple of points
But it's not
related to
even
that.
defended. They're not being asked to defend a product. They're just being asked to produce some,
Correct.
documentation
Yes.
with respect to a product. Right? I mean, there's
Right,
a
and
difference.
we are here on discovery, and I would like to point out that the characterization of the case law as controlling and clearly established precedent is inaccurate, as we point out in our response. In no case, even though cited by this defendant, has an appellate court required the showing of substantial similarity with regard to the same product that is at issue, the same product that allegedly caused the harm that is here. And here the product is Flex Seal Clear. And the only requirement for showing substantial similarity is as set forth in the cases they cite with the Alvarez v. Cooper tire case. It starts with the broad scope of the discovery rule. In product liability actions, when a plaintiff seeks discovery regarding other products manufactured, Florida courts have uniformly held that the other products must be substantially similar to the subject product, citing Nissan Motors v. Espinosa American Medical Systems, Caterpillar Inc. Versus Keskes. And so there is no showing here that we're not seeking discovery related to another product. We're seeking discovery related to the very product that is at issue here, which is Flex Seal Clear. There are other types of products under the Flex Seal name. There's a Flex Seal tape, there's Flex Seal Black, there's Flex Seal White, but it is very clear that we're only seeking discovery related to this product at issue. The petitioners, excuse me.
On the question of jurisdiction, though, so the Supreme Court has expressed concern or sensitivity in other contexts, recognizing that we are a court of limited jurisdiction in some ways. We typically only get to review final orders, and as you know, and everyone knows here, and orders, non-final orders that are enumerated in 9130 and a couple other spots in the appellate rules. Other than that, we don't have jurisdiction to review orders. And that's what makes certiorari so extraordinary, is that it's really an end run around our jurisdictional limitations. And the Supreme Court has shown sensitivity to that in other cases, including like motions to dismiss and those kinds of things, because there's not a limiting criterion with respect to that. If we start looking at motions to dismiss for a variety of reasons, it's unduly burdensome to have to defend against this whole case when we know, that maybe it's not entirely meritorious. So in the context of discovery, what would be the limiting criterion that we would apply to not have cert be used all the time to review discovery orders, orders compelling discovery, when the party on the receiving end of that order doesn't like it, thinks that it's just too broad, and then tying it up and tying this court up for a while.
Well, I think the framework that has been established, where it is likely to lead to a cat out of the bag type of evidence,
Which is trade secrets. So
information.
a substantive right is at stake in those situations. Statutory privileges,
Yes.
trade secrets, that kind of thing.
Yes.
That's one. That's
here,
one criterion.
There was an argument made about trade secret information. Certainly, the trial court just today entered the written order denying the motion to stay and setting forth the requirements for the production of a privilege log. So the petitioner will have an opportunity to identify any privileges that it seeks. And so, again, there's opportunity to protect against the disclosure of trade secret information or the disclosure of confidential business information. We're not even there yet. I mean, we have not, this discovery was served in November of 2021. There have been no documents produced.
If we dismiss the cert, let's crystallize this a little bit more. If we issued an order dismissing the cert petition on the ground that the petition seeks review based on overbreadth or something along those lines, and that we don't have jurisdiction, there's not a limiting jurisdictional principle for that. We don't have jurisdiction to consider such petitions unlimited that not tied to a trade secret or some other statutory right. Would that be conflicting with any Supreme Court decision that you're aware of?
I do think it, as I understand it, which is the same as Ms. Walbold, in that the two prongs, the irreparable harm go to the jurisdiction, the departure from clearly established requirements is to the merits, and so, well, I think
Yeah, hold
certainly-
aside I'm not talking about the departure
Right.
from the essential requirements. I'm just talking about material injury that can be
Okay.
remedied on direct appeal.
If there's no material injury, because there's been no identified harm or reparable harm
Which
that you
is
can't correct.
invariably is tied to the idea of like the cat out of the bag type
Mm-hmm.
of stuff. Like if you don't have a statutory right of some sort that you can't get back at the end, if
Mm-hmm.
that's not present and it's just man, it's going to be like a train car or 5 train cars worth of documents that we're going to have to cull through and produce. That's the only harm, so to speak. Is there anything from the Supreme Court that precludes us from saying or dismissing the petition on the basis like that assertion on its own can't be irreparable harm to support jurisdiction in cert?
I don't believe that's inconsistent. I think that's very consistent with the Board of Internal Improvement Trust Fund case, which stated that overbreadth can't be a measure for granting cert relief. And here, the argument that there is somehow some legal irrelevancy to the documents that we are seeking and that the judge has ordered carte blanche discovery is plainly not borne out by the narrowly tailored relief that the judge has granted, specifically related to this product, but also completely distinguishable from the cases they rely on in an attempt to show that somehow this discovery is legally irrelevant, which were the 2 public slip and fall cases and a case involving a charging lien where it wasn't even related to the litigation below. This is not a case where the discovery that's sought is legally irrelevant. It's plainly relevant to our causes of action, which are strict liability and negligent failure to warn and products liability claims.
But just for the sake of argument, their position is that you're trying to, again, I'm not endorsing it or rejecting it out of hand, but their position is that the products you're attempting to discover are not the product that caused the alleged injury. So therefore, it cannot be reasonably calculated to lead to admissible evidence.
We disagree with that assertion. First,
Well, how is it how is it reasonably calculated to lead to admissible evidence?
because we have alleged that there was both strict liability and that this defendant released highly dangerous products without adequate warning and instructions, and that if, as Your Honor pointed out, if the evidence was that in an attempt to make this product less flammable, in fact, it made it more flammable, then that would go to show that this product was unreasonably dangerous, and that the evidence would be directly relevant to the plaintiff's claims.
Counsel for petitioner, responded to my questions along these lines by saying, well, you didn't make these arguments below. I'm not going into preservation, I'm just asking questions about, so what is your burden, do you think, below regarding obtaining this discovery? Because
Well-
counsel for petitioner said it's your burden to show evidence, which I'm not sure how you show evidence when you don't have the discovery, but go ahead.
Yes, how can we show it's, if we don't have the evidence to show? I would disagree with her characterization of what we argued below. She seems to suggest that just because we showed a can that was related, that was the same product, that somehow we said, oh, it's all about the appearance of this can. And that's not accurate. The reason we didn't argue substantial similarity is because we weren't seeking discovery related to other models, other makes, and other models. We were seeking discovery related to the very same product that is alleged to be an issue in the complaint, which is the Flex Seal Clear. And so we had no obligation to come in and show substantial similarity as demonstrated by the language of the Alvarez case, citing these other cases. And there's been no Florida case law that requires the level of specification that the defendant seems to suggest here, which is that not only do we have to show it's the same product that's at issue, that we have to show it was manufactured according to the same specifications during the same time period. And that is nowhere found in these cases. And in fact, I would point this court to the Caterpillar versus Keskis case, which is relied on by Nissan versus Espinosa and also the American Medical Systems cases. And in that case, in the Caterpillar case, it related to incident reports from a tip-over of a forklift. And while the appellate court, under the overbreadth analysis, which would subsequently, as we know, would not be upheld now, but even in that case, although the Fifth TCA, I think it was, found that there was no relevance, no showing of substantial similarity with regard to 73 other different models in the forklift, the court did specifically allow 5 years' worth of incident reports going back to the time that that particular model of forklift first was made up until the date of the incident. And so that goes to show that there's been no limitation with a requirement that we have to show that the same product that our plaintiff used was made to the exact same specifications, and that we're only entitled to discovery related to the post-2019 changes. That level of specificity and requirement does not exist in the case law. Again, the only need to show substantial similarity is when you're seeking information related to other products, other makes and models.
Do you think go ahead, I'm sorry.
That all goes to the merits.
Yes.
Getting back to the jurisdictional question here, there seems to be, it's an artificial distinction between the jurisdictional elements, if you want to call it that, and the departure from the essential requirements of law element. Because, in a way, if there's not an essential requirement of law that's been departed from, it's harder to argue what the irreparable harm might be. Like, again, using the cat out of the bag, that's an easy situation because you have an actual statute, some legal right, some substantive right that's being violated that you can point to. You can say, well, the court departed from that, and it's a miscarriage of justice, which is the other aspect of this, sort of the overarching consideration here. It's a prerogative writ. Here we're talking about it's purely procedural. The discovery rules are purely procedural, at least typical civil discovery. We're not talking about a statutory right to discovery. I'm just talking about like this kind of discovery we're talking about here is purely procedural. You don't have a right to discovery, and presumably you don't have a right to refuse discovery unless it violates some other right or something like that. So in this instance, trying to square all of this together, when it's overbreadth, which it seems like they're arguing, that's the harm. How do we consider that and consider whether there's been a miscarriage of justice if we don't have an essential requirement of law in the first place that's being departed from, other than a discovery rule, which is procedural? That was a very long word. No periods or commas in any of that, but do the best you can.
I think the Florida Supreme Court's decision in Garcia is helpful because even though as Your Honors have pointed out, there was a suggestion that by ordering to disclose this passcode, it would lead to all sorts of problems for that particular criminal defendant at trial. But even there was not irreparable harm incapable of remedy. There was availability.
That's what I was going to ask,
relief.
actually, is Garcia a sea change? I don't understand how any purported violation of a discovery rule, other than a statutory right to trade secret or some other privilege, can now ever invoke an appellate court's jurisdiction. If a criminal defendant can go to prison under a life sentence and his only remedy is on direct appeal, how can a mere civil corporate defendant or any other civil defendant or civil petitioner ever have a right to invoke an appellate court's jurisdiction if the argument is based on a very narrow, substantive right, such as trade secret?
Well, I think trade secret's different from overbreadth. I mean.
Oh, I know.
I'm
I'm asking does Garcia indicate a real sea change in your opinion?
I don't believe so. I think it's consistent with a lot of Florida Supreme Court case law. I mean, it certainly cites to and considers a lot of Florida Supreme Court case law, including, Combs and Martin Johnson versus Savage. I think, it's just an evidence of the limited view that the Florida Supreme Court takes of the ability to seek certiorari relief. And here, just like in Garcia, this defendant would have an opportunity to seek relief on post-judgment appeal or final appeal should
And
we
fact,
get to questions of
right,
admissibility, not discoverability.
In fact, wouldn't the harm only occur if you obtain this information and it's improperly admitted at trial? That's the harm, right?
That's the harm, and I think otherwise there are certainly protections to prevent against the disclosure of trade secret, violation of confidentiality.
And I'm glad you brought up Savage. Just to touch on that a little bit, I'm having a hard time if we were to accept jurisdiction even in this type of cert petition, and I don't know what the legal principle that we could come up with as a limiting principle that wouldn't conflict or be inconsistent with what the Supreme Court said in Savage, for instance. Can you think of a way to reconcile that?
I have not.
I mean, it's what I brought up before. They've
Right.
expressed concern, like how do we limit this and keep it from, in keeping cert from eating the jurisdictional limitations of the DCAs? And it seems like a cert petition like this that's claiming almost entirely just overbreadth as a basis for relief, that's corporations make that objection in every single civil case. I'm guilty of it myself when I was representing corporations. Is there a limiting principle in this? And I think that's one of the
Right.
fundamental questions here.
Well, I mean, I think you can go back to Board of Internal Improvement and say overbreadth is not. I mean, that's a limiting principle from the Florida Supreme Court, that overbreadth is not a basis for demonstrating irreparable harm. And it is under Allstate and the other cases addressing the cat out of the bag where there's disclosure of confidential or protected privileged information that could then be led to injure, I mean, in the sense of harming someone if that information is disclosed. Those are your principles. But here, I agree with you. It is almost entirely overbreadth with some issue as to confidentiality that will be remedied by this trial court's subsequent order. So we would ask this court to dismiss or deny the cert petition. Thank you.
Thank you. Madam Clerk, would you please add 2 minutes to the petitioner's time? Thank you.
I want to start with Judge Tannenbaum's question, which I think several of the questions went to, and I suggest that the limits on your certiorari jurisdiction is already established. It's established by the Supreme Court in Internal Improvement and in Langston, and it sets forth the test for expressly sets forth a test of when certiorari jurisdiction is appropriate in discovery orders that grant carte blanche, which this does. All models of this product since they've been manufactured for more than a decade, and I suggest those limitations are what this court should apply, and I remind the court that the second and the fourth have both, since Internal Improvement, cited Langston, followed Langston, applied it in determining that they had certiorari jurisdiction to quash discovery orders those were slip and fall cases, and the discovery was being
Sure.
sought in prior stores and
But what-
other stores and the
but what
like.
is
But
the-
that, I
what-
suggest, gives you the test that you need.
What is the substantive right, so constitutional right, statutory right, that your client has that's being invaded such that this order compelling discovery, it violates that, and it will result in a miscarriage of justice, miscarriage of justice?
It has a right to be free from discovery about products that have not been shown to be substantially similar with respect to the matters that are at issue in the case, and that it is the plaintiff's burden, not my burden, to come and show that they're not substantially similar. We did, but it's the plaintiff's burden, and we've been deprived of that procedural
what is-
right to have the plaintiff be required to come forward with evidence that this is not substantial, that they are substantially similar.
But which provision of the Constitution or which statutory provision gives your client that right?
I'm sorry, Your Honor, just had to bear with me. I can't point to that. You have lots of rights that aren't in the Constitution. It's a right that is established by the law that was binding on this trial judge.
But isn't it just an
that-
interpretation? I mean, again, going back to my point before, I mean, discovery is purely procedural, is a creature of the courts, and only the creature of the courts. And so, in assuming that courts don't have the authority to create rights out of whole cloth, which is substantive law, where would this idea, this right to be free from onerous discovery, overbroad discovery, where does that come from?
But we have a right even under, it comes from the discovery rules, and it comes from the established case law that the trial judge was bound to follow. And if I could, because I know I'm running out of time, I want to make sure, Judge Thomas, you understand, there's been plenty of discovery about the prior models. The plaintiff knows exactly how the prior models were designed and knows their specifications, and we've not suggested they can't get into discovery about that. What we've said was that the discovery request here will go far, far beyond that, including all lawsuits, all claims that have ever been filed with respect to any of these models. And as to the contention that they're the same product, that's the identical argument that was made in the second district's decision that the fourth followed in the Osborne case. Is the identical issue that this is just the same product, it's just different models of the same product. And the second and the fourth both quashed the discovery and exercised their certiorari jurisdiction. Judge Tannenbaum, you said that the certiorari is an end run around the appeal, and obviously to some extent it is, but it's also a safety net. And it's a safety net for when there's no way to correct an error on appeal. And once this production is made, it can't be undone. And we can't have the right to have the plaintiff carry the burden that the courts have just for years and years said is their burden to get this discovered.
But what is the inherent harm in producing records, some of which may not be used, some of it may not be entirely relevant? The quote, getting it back, doesn't apply the same way as like a trade secret. A trade secret loses its nature as a trade secret once it becomes public, and that right then is eviscerated, and you can't get that back on appeal. It sounds like we come back to the same question. It sounds like the harm here, or the burden, or the irreparable harm that you can't get back on appeal is the inconvenience of going through voluminous records and producing them, calling through them to identify attorney-client privilege, trade secrets, and that kind of thing.
I come back to the burden of proof because that is a substantive right that we've been deprived of, and then that's usually considered irreparable harm. All I can say, Judge, is the second and the fourth have both found, easily found irreparable harm where a defendant is required to make a massive production of very sensitive business things they hold confidential, things that would be useful to competitors to know, and now they're being required to produce them without any showing that it has any relevance whatsoever to the actual product that's alleged to have injured the plaintiff. Thank you.
Thank you for your time. Thank you both for your arguments. The court is in recess.
All rise.